Hello friends, today we're going to talk a little bit about what many consider to be a four-letter word, alimony, specifically the different types of alimony that are awarded by Florida courts. Welcome back to the Divorce Broadcast channel. My name is Manny Segarra, coming to you from Miami, Florida. When it comes to an award of alimony, courts refer to Florida Statute 61.08. Upon review of that statute, you will see that one of the initial assessments by the court is the financial need of the person requesting alimony or asking for alimony versus the ability to pay of the person for which alimony is being requested. If the financial disclosure shows that the person requesting alimony doesn't have the financial need, or that their job or that their income covers their expenses, then they may not qualify for alimony. However, on the other hand, if the person who is being requested to pay alimony, they don't have, according to their finances or according to their income, they cannot pay alimony, or they don't have enough money to cover their own basic needs, then perhaps they won't have to pay alimony. There are other factors that the court will consider. As of the date of this video, there are about 10. I'm not going to go over all 10 of them because that could be a video in and of itself, but I will mention a few of them. The court will consider the standard of living during the course of the marriage, the financial resources of the parties, the age, physical and emotional condition of the parties, the earning capacity, educational level, and vocational skills of the parties, all sources of income. If one of the party has more responsibility with the children of the marriage than the other, these are some of the factors that the courts will consider in Florida. But one of the factors that I do want to key in on is the duration of the marriage. Florida sets terms for marriages. If it is a marriage of 0 to 7 years, it is considered by the courts a short-term marriage. If it is a marriage from 7 years to 17 years, it is considered a moderate-term marriage. And if it is a marriage over 17 years, Florida courts consider that to be a long-term marriage. The length of the marriage is determined from the date that the parties got married to the date that one of the parties filed a petition for divorce. You will see why that's important in a little bit. Now, let's talk about the different types of alimony. Let's start with the first one, bridge the gap alimony. Bridge the gap alimony may be awarded by a court to assist a party by providing them with support so that they can make a transition from being married to being single. It's designed to assist the party with the legitimate short-term need, and it cannot exceed 2 years. Examples may include the need for moving expenses to the new residence, perhaps a little bit of assistance with rent, assistance with the car payment, car insurance, or medical insurance. It can terminate upon the death of either party or remarriage of the person receiving bridge the gap alimony. Bridge the gap alimony is non-modifiable as to amount or duration. So that's the first type. The second type is what's called rehabilitative alimony. Rehabilitative alimony is awarded to assist a party in establishing the capacities to self-support themselves. The assistance will be either through redevelopment of some previous skills or credentials that they may have had, or the acquisition of education, training, work experience, or some sort of vocational skills. Examples include, for example, real estate agent. If you're a spouse, you're getting divorced, and you want assistance getting your real estate license, rehabilitative alimony may be a good option for you. There must be a specific and defined rehabilitative plan, and it can be modified or terminated in 3 circumstances. Number 1, it has to be a substantial change in circumstances. Number 2, upon non-compliance with the rehabilitation plan. Or number 3, upon completion of the rehabilitation plan. So if the plan requires you to go to school to get your bachelor's degree, if you make it after 4 years, get your bachelor's degree, then the rehabilitative plan is over. But if you stray and don't finish, they can cancel or change, modify the rehabilitative plan. The third type of alimony is what's called durational alimony. Durational alimony is awarded when permanent alimony is not appropriate. It is to provide assistance for a set period of time following a short-term or a moderate-term marriage. A lot of times it could be half the length of the marriage. So if it's a 12-year marriage, sometimes it'll be alimony for 6 years. Sometimes it'll be a little bit more. It's just an example. But one of the things that it cannot do is durational alimony cannot exceed the length of the marriage. Durational alimony will terminate upon the death of either party or upon the person receiving alimony getting remarried. Durational alimony can be modified upon a substantial, or at least the amount of the durational alimony can be modified upon the showing of a substantial change in circumstances, but the length of durational alimony may not be modified unless there are exceptional circumstances. Finally, the last type of alimony that's contemplated by the Florida statute is what's called permanent alimony. Permanent alimony means what it says. It means it's alimony for life, and it's awarded to provide for the needs and necessities of the life as established during the course of the marriage for the party that lacks the financial resources and ability to meet their own needs and necessities. Permanent alimony is awarded after long-term marriages. It can be ordered in a moderate-term marriage if you can show by clear and convincing evidence that these factors are also met. But it can only, and when I say permanent alimony can only be ordered in short-term marriages only during exceptional circumstances. If you look at it, it makes sense. If someone's been married for 20 years, they get divorced, and they dedicated their life to support their spouse, and now they don't have that income anymore, permanent alimony is permanent. It is ideal for that type of spouse. An example of when permanent alimony may be ordered in a short-term marriage could be if there's some sort of accident in which the spouse was left disabled or injured, or if there's some sort of illness that they suffered through that caused them to not be able to take care of their own needs. So, each case is different. Permanent alimony can be terminated upon death of either party and upon remarriage of the party receiving the alimony. It can, however, be modified if there's a substantial change in circumstances, or if the person receiving the alimony is in a supportive relationship under a different statute, 61.14, which is a whole set of factors which we will go over at some future time. So in sum, those are the 4 types of alimony that are listed in the alimony statute in Florida. Obviously, the factors are very important to consider, so each case is different. Take a look at the factors. The courts will determine need versus ability to pay, and we'll talk about supportive relationships in the future. That is the word on alimony. Thank you. Remember, please like this video, subscribe to our channel. We have offices in Miami and Orlando. If you need assistance, or if you know someone that needs assistance with alimony, have them look us up at www.segarralawfirm.com, se habla español, and share this video with friends, colleagues, and family who are paying alimony. Thank you.